If you have an employee handbook, you have to have an FMLA policy in it if you're subject to the FMLA. For those of you that raised your hand that had 50 or more employees, and that's all employees, you know, anybody that shows up on payroll, then you have to have this policy in there. Even if as the FMLA policy works out, your employees are too spread out, nobody actually has FMLA rights. But this law has been changed several times over the last couple of years, particularly with the area of military leave obligations. And so all policies need to be updated. The general rule is that your policy in your handbook has to have all the information in the Department of Labor poster. You can go right on their website and see what that is. Non-competes and trade secrets. In this day and age, that's a big issue for a lot of our clients. You know, everybody, you know, if you're a sales entity and you rely on customer names and customer lists, you want to make sure that that information is private. Or if you're doing, you know, more technologically advanced things, you've got, every business has what they would view as their trade secrets. Their private information they're not making public that gives them some kind of competitive advantage in the marketplace. And so you need to think through, what are we doing to protect that information? There are laws that just generally provide provide protection for trade secrets, but to be honest with you, they're really hard to enforce in a litigation setting. You know, do you need a non-compete? Is this somebody that if they left the organization, they're going to really be able to take a lot of business with them? They're going to really be able to hurt the organization? Not in South Dakota, non-competes are generally enforceable if they're well drafted, if they're for 2 years, and they're for a reasonable geographic area. You have to be able to prove that that person has the ability to harm your business if they leave. So, you know, it's too late to be calling the day you're going to fire them and ask, you know, about non-compete issues. You're going to fire them, but you're really worried that they're going to go work for your competitor. Well, courts are not very sympathetic to that. We talked about discrimination a little bit when we kind of went through all those different laws. There are some other issues that kind of sneak up on people sometimes. If you've got 100 or more employees, you're supposed to file this EEO-1 form. It doesn't get a lot of press, but if you get audited by the Office of Federal Compliance, they're going to ask for that. And so if you've got 100 or more employees, that's something you need to look into. You also might have to have an affirmative action plan. If you've got any kind of government contract, you need to be careful. Most, you know, in that 50-page contract you signed with the government that's in really, really small type, they probably have a provision in there that you're supposed to have an affirmative action plan. Banks get pulled into that through deposit insurance and things like that, or because they sell government bonds. There's some tricky ways. They're trying to pull all hospitals into that. That's been litigated, and there's not necessarily a clear answer on that. It kind of depends on who you ask. The government thinks there's kind of a clear answer on that. But so those are things that you have to, that's something the EEOC is really, you know, they're really focused on discrimination and diversity and whether you're doing everything you can to have a diverse workforce. And they will look at those plans and take that pretty seriously. Now we're getting into the nitty-gritty of what I would consider more common gotchas, and particularly with small employers and things that get people in trouble. Nobody in government likes independent contractors, generally. And so you have to be really careful about people that you're categorizing as independent contractors. If they are, for South Dakota law purposes, they have to basically be in control, like you do for federal law purposes, but for South Dakota law purposes, they also have to essentially have their own tax license. In my mind, one of the best cases about this wasn't so good for the employer at the time. But how many of you have you ever been out to the restaurant where the ladies come by with the roses, they're trying to sell you the roses, you know, or trying to sell your significant other, your husband, a rose? Well, I mean, those were just women that's how they picked up some extra money. They'd go around and sell those Well, they were treated all as independent contractors. But it's not like they're in the business of selling roses. You know, they had other jobs, and they just did that on the weekends or something. And they weren't paying unemployment compensation on those folks, or giving them any benefits, or paying taxes on their wages or anything. And they got slammed that they were not in compliance with state law, which meant they weren't in compliance with federal law either. The case was focused just on state law. But I have a client every year that issue sneaks up on, that they've hired people and they just, just because they had a need. They had a need to get some people in there for a short period of time, or people who had other jobs that were just doing this kind of on the side, and it was easier for everybody. I mean, the employee included didn't want to be treated as an employee. They didn't want to have stuff taken out of their paycheck. They didn't need the benefits, whatever. And so you have to be careful, because if you guess wrong on that, it is really messy. Because you've got taxes you haven't paid, you have benefits that you haven't paid. One of the big independent contractor cases federally was with Microsoft, because Microsoft would hire all these software technician folks, and a lot of them they treated as independent contractors. Well, then they didn't give them stock options, they didn't put them in their retirement plan, and then the courts came in and said, well, I mean, they're employees, they're doing the exact same thing as the software engineer sitting at the next desk that you treat as an employee, and so you owe all these back benefits, and that is ugly and expensive. So you want to be careful about that. Temp employees sneaks up on people too. They'll stick somebody in and say, oh, I don't want to give them benefits, I'll just call them temp. Well, after about the 5th year that they work for you, it's kind of hard to argue that they're still temp. If I had to pick a number 2, like the top 2 gotchas, at-will employment would be the number 1. This would be number 2. Trying to decide whether your employees are exempt or not, whether I have to pay them overtime or not. I am amazed sometimes, but it makes sense. How many people think that every one of their employees are exempt? I have clients that will come in and then we start talking about this and they're like, well, they're all exempt. They're all important. They all exercise discretion and independent judgment, because that's one of the tests up there. You have to remember that the Department of Labor starts with the position, and the law starts with the position that everybody is subject to, everybody gets overtime. The burden is on you to prove that somehow they get an exemption from overtime, from being paid overtime. And most people get this exemption on one of these white-collar exemptions. And some of them are easy. An executive, if you manage 2 or more, the equivalent of 2 or more full-time employees, you're an executive and you're exempt, and you get paid on a salary. You have to be paid on a salary as well. Professionals, doctors, lawyers, CPAs that are actually practicing in public accounting, those kinds of people are exempt. It gets a lot harder when you start getting beyond that. Administrative employees. Frankly, I think the Department of Labor does a huge disservice to people. You go out to their website and pull some of the stuff they have on there, and it does sound like a lot of people would be exempt. You have to really dig down, drill down pretty deep to realize how narrowly that exemption is really defined. But if you just go to the Department of Labor website, they'll define it as employees that are salaried and whose jobs require discretion and independent judgment. Well, who hires somebody that you don't expect them to exercise some independent judgment, you expect your janitor to exercise some independent judgment, Does that need to be done or not? Our receptionist is like, she screens things. She knows, is this a call I'm supposed to send on to somebody else, or is this a call I need to do something else with? We'd have computers doing it if we didn't need some discretion and independent judgment involved. But that's not really what that exemption is designed for. It is designed for kind of high-level management, people who sit on the executive team, people who are in charge of different divisions. It's a very gray exception, and because of that, there's lots and lots of litigation over that. But generally, if I'm fighting with a Department of Labor investigator on behalf of one of my clients, it's over that one and the computer one. Those are the two ones. The computer one also is very difficult, particularly if you're relying on the stuff that's on the Department of Labor website. I had a new client come in that was referred by a CPA here in town that I very much respect, very good at what they do. And the CPA was sure that most of their employees were exempt as computer professionals. The business dealt almost primarily with computers and technology, and so they thought that for sure that these people all fell under that exception. Well, that computer exception, if you drill down into that, is really for people who are software designers, or people. It is not for your tech guy that comes around and saves people like me on a daily basis who can. If I can't fix it by rebooting it, then I'm done. And so, but those people are not exempt generally. Just because you use a computer for work, used to be, I get a lot of those questions. People just figured anybody that used a computer for work was really smart and that they were exempt. It's really designed for very high level computer professionals and not hardware people generally, unless you're designing hardware. Just because you fix hardware or can deal with hardware, that's not necessarily for you. There's an outside sales exemption. It doesn't apply to inside sales. So if you mainly sit at a desk and are on the telephone calling people, or you sell shoes in a shoe store, that exception does not apply to you. So all of these are very, they sound big, but they're really pretty small when you get right down to it. And these can be expensive mistakes too. If you get audited, and frankly, most of my clients get audited unless they are big organizations with lots of, with good full-time HR staff, or they've been audited in the past and then they kind of fix their problems. There's lots of different ways to make mistakes under these laws.